Hey everyone, welcome back to Office Hours. I am so thrilled you're here with me for this explainer. Today, we are going to completely master alternative contract remedies so you can absolutely crush your final exam. I want you to think of me as your mentor today. We're going to take these big, intimidating legal rules and we're going to break them down so simply that honestly, a seventh grader could understand them. So, if you've ever wondered what actually happens when someone breaks a promise and standard money damages just don't cut it, well, you are in the exact right place.
Here's our game plan for today. We're looking at 1. When money isn't enough. 2. Is the breach material? 3. Restitution versus damages. 4. Our specific performance checklist. And 5. Some real law exam practice scenarios. Let's get to it.
All right, diving right into part 1, when money just isn't enough. Moving beyond expectation damages. This is exactly where the magic of alternative remedies comes into play. Usually, contract law has a very specific goal, right? It wants to put you in the exact financial position you'd be in if the contract had been perfectly finished. We call these expectation damages. But what if the contract was just deeply flawed? Like, what if you paid a massive deposit and the other guy just walked off the job? Or what if you signed a contract to buy a completely one-of-a-kind piece of land and they suddenly refused to hand over the deed? Money doesn't always fix those specific problems. So when standard expectation damages fail us, we need alternative tools, namely restitution and specific performance.
Moving to part 2. Is the breach material? The threshold for termination. Because look, before we can even discuss those cool alternative remedies, we have to clear a major hurdle.
We have to know if a contract can actually be terminated due to a breach in the first place. Not every broken promise lets you cancel a deal. So if you see a fact pattern on your exam about, say, a delayed delivery, you want to use this 3-step checklist from the Emmanuel Law Outlines case. In that case, a study guide publisher was a month late delivering a supplement because of a medical emergency. The buyer tried to just cancel the whole multi-year contract. But the court said, hold on, not so fast. First, check the contract. Did the buyer give proper written notice of the breach? Second, did the delay substantially impair the entire contract? And third, did the breaching party clearly repudiate? Like, did they flat out refuse to perform? In the Emmanuel case, the buyer didn't give proper notice, and the delay didn't ruin the whole deal, so no cancellation.
Let's really break down that term substantial impairment because it's absolutely crucial. It is a very high legal threshold. It means the defect practically destroys the essential value of what you paid for. Think of it kind of like ordering a pizza. If the delivery driver forgets your side of garlic dip, that's a minor breach. It's annoying, maybe you get $1 back, but you still have to pay for the pizza. But if they deliver a completely empty box, now that is a substantial impairment. You get to cancel the whole order. That's the difference you need to be looking for on test day.
All right, on to section 3, restitution versus damages. This is one of the most confusing areas for law students, so we're going to perfectly contrast the two. I want you to literally split your brain into 2 different timelines here. On the left side, damages look forward. You're looking ahead to the finished promise, like a fully built house, and you're calculating the money needed to get you to that finish line. But on the right side, restitution looks backward. You are basically pretending the contract never even happened, and you just want a refund to prevent the other guy from keeping your money unfairly. The law calls this preventing unjust enrichment. Okay, write this key term down, quantum meruit. It's a fancy Latin phrase that basically means as much as he has earned. It's a cause of action seeking the reasonable value of services rendered. Let's say you hire someone to build a beautiful brick fireplace in your living room. You pay them a $10,000 deposit, they dig a hole, leave a pile of dirt, and just walk away forever. Quantum meruit ensures you can look backward and get that deposit back, because the builder would be unjustly enriched if he kept it for doing nothing.
But here's a massive twist that examiners absolutely love to test. What if the person who broke the contract is the one asking for restitution? Well, under the old common law, they got absolutely nothing. But under the modern approach, coming from Restatement 374 and the Lancelotti v. Thomas case, contract breakers are not outlaws. Even if a builder breaches, they can still get paid for the actual value of the work they completed, minus the cost of the mess they made. We offset the benefit they provided by the actual damages they caused.
Now let's explore a brilliantly wild concept, the loss contract exception. This is famously seen in the Algernon Blair case. Imagine a builder takes a job but realizes halfway through they completely underpriced it. If they finish, they're going to lose a ton of money. But suddenly, the person who hired them materially breaches the contract and wrongfully fires them. Instead of suing for expectation damages, which remember would be 0 since they were going to lose money anyway, the builder can sue for restitution. they can get the reasonable market value for the labor and equipment they already provided, entirely ignoring the terrible contract price. It's a total game changer.
But wait, there is a huge glaring trap here called the full performance exception from the Oliver v. Campbell case. If you have already finished 100% of the job and the only thing left is for the other person to pay you a set agreed-upon price, you cannot use restitution. You must sue for that exact contract price. You can't suddenly claim your services were worth double the contract just because they paid you a few days late. Keep that in mind.
Moving right along to Section 4, our specific performance practice checklist. Let's see how specific performance builds upon these concepts. This is when the court doesn't just hand over money, it forces you to do exactly what you promised. You've got to memorize this simple 3-step checklist for your exam. Ask yourself, 1. Are money damages strictly inadequate? 2. Is the item or the piece of land totally unique? And 3. Is this absolutely not a personal service contract? If you can confidently answer yes to all 3 of those, you might just get a specific performance decree. So what makes something legally unique? Well, it all comes down to cover. Under the Uniform Commercial Code, cover means your ability to find substitute goods in the open market. Take the Laclede gas case, for example. A supplier tried to back out of a long-term contract to provide propane to a residential neighborhood. The court ordered specific performance. Why? Because during an energy crisis, the buyer couldn't just easily go out and cover or replace that massive long-term supply anywhere else. That propane contract was legally unique. Oh, and one more thing. Specific performance is an equitable remedy. To get equity from the court, you must have acted fairly yourself. This is legally known as needing clean hands. If you lied or tricked the seller or acted dishonestly during the contract creation, the judge is going to throw your specific performance claim right out the window.
All right, let's bring it all home with Section 5, Law Exam Practice Scenarios. Knowing the rules is great, but applying them is what gets you the A. Let's run through some rapid-fire Socratic practice questions to lock this in.
Scenario 1. Imagine a contractor just walks off the job halfway through. Clear breach, right? But they had already dug a valuable foundation worth $5,000. However, leaving the job site a mess caused $1,000 in damages to the homeowner. The breaching contractor wants restitution for that foundation. Can they recover anything?
The answer? Yes. And here's exactly how you'd write the essay. Under the modern trend of Restatement 374, a breaching party is not an outlaw. They can recover in restitution to prevent the homeowner from being unjustly enriched, but the court's going to offset the math. We take the $5,000 benefit conferred, subtract the $1,000 in actual damages caused by the breach, and the breaching contractor recovers $4,000. Boom, full points.
Scenario 2. You hire a world-famous celebrity chef to cook exclusively at your restaurant for a year. It's a huge deal. On day 1, the chef breaches the contract and refuses to cook. You sue for specific performance, demanding the court force the chef into your kitchen. Do you win? Run it through our checklist.
No way. Absolutely not. You can never ever force someone to perform a personal service. And the reason is massive. The 13th Amendment of the U.S. Constitution strictly prohibits involuntary servitude. Forcing a human being to work against their will is unconstitutional. So, while money damages might be totally inadequate to replace a celebrity, you are strictly limited to suing them for cash.
Scenario 3. This one's tricky. A private seller signs a contract to sell you a rare Da Vinci sketch for $100,000. At the last minute, they refuse to hand it over. You really want that sketch. However, the art museum next door actually owns an identical, authenticated copy of the exact same sketch, and they're willing to sell it to you, but for $1 million, 10 times the price. Can you get specific performance against the original seller?
Classic exam trick right here. The answer is no specific performance. Why? Because you can technically cover. Since an identical substitute exists and the museum is willing to sell it, the item is no longer legally unique in a way that prevents a monetary fix. The court will deny specific performance, but they will award you massive expectation damages. The breaching seller will have to pay you the $900,000 difference so you can go buy that sketch from the museum.
So, what's the big takeaway here? When standard money damages fail, you really just need to ask yourself one question. Are you looking backward to strip away unjust enrichment and restore fairness? Because if so, you want restitution.
Or are you forcing future action because an item is completely irreplaceable and no substitute exists? Because if so, you're looking for specific performance. Keep that fundamental distinction in mind, and you will absolutely ace this section of your exam. But before we go, I want to leave you with a bigger question to ponder as you study. Is the law of remedies actually about delivering absolute justice, or is it merely about economic efficiency? Think about that, and I'll see you in the next explainer.